Good morning, everyone out there at WTOB. This is attorney Dylan Greenwood along with attorney Harold Eustache here on For the Record with Greenwood Law. Last week, we talked about your First Amendment rights, where you get them, how it affects you, how far that really goes. And I think we learned that it doesn't quite go as far as some of us think. And today we're kind of moving along in the Bill of Rights. So we're looking at something that implicates the Fifth and the Sixth Amendments of your Bill of Rights, and that is Miranda. I'm sure almost everyone out there has heard about Miranda Warnings. If you've ever watched the TV show Cops, you've definitely seen that. The typical thing is you have the right to remain silent. Anything you say can and will be used against you. You have the right to an attorney. If you cannot afford that attorney, one will be appointed to you. And so those, the first statement there implicates the Fifth Amendment. The second one about an attorney implicates the Sixth. Where most people think that Miranda applies to them is that Fifth Amendment aspect of it. It's the speech part. And we, field calls all the time. People call us up about what's going on, or they're telling us about their case, and they go, Mr. Greenwood, you need to know they never read me my Miranda rights. So that's going to be good in our case, right? That's going to get me out of this. They violated my rights by not reading Miranda. We always have to kind of pause there and say, well, that doesn't necessarily mean the fortuitous thing that you think it means. In every single case. And I know you've seen that too, haven't you, Harold?
I have a lot. And, part of what we do so much is field these calls. And a lot of times a typical call, let's say it's a DWI and an officer stops a person and they go through standardized field sobriety tests and they end up getting arrested. And the officer, puts the person in their patrol vehicle, drives downtown, and they go through the DWI process, but the officer doesn't talk to him, doesn't say anything else to the person that's been arrested. And later on they talk to us and say, well, I was never Mirandized, and that should get me out of these charges. And generally, I'll tell somebody, well, did the officer ask you any questions after you were arrested? And if the person says no, a lot of times, not only Miranda may not apply, but even if it did apply, it wouldn't necessarily have any real impact on that person's case. So it's important to understand what Miranda does and doesn't do. And so today we're going to go through just what Miranda is, kind of how the case came about, and then how it applies to you.
Yeah, so when you're looking at this, and we said that it implicates the Fifth Amendment. And most people know the Fifth Amendment is a right against self-incrimination. I'll plead the Fifth. I think it was Dave Chappelle's favorite. Yeah, it was his favorite amendment. There are all these different ones, but the Fifth was his favorite. And that's the way most people look at this in the context that they don't have to make statements against their own interests. They don't have to incriminate themselves. You don't have to testify at a trial. There's nothing that compels you to do that. And Miranda was implicated there because there was a number of different police tactics used leading up to it, and all of a sudden it became an issue. But when we're looking at these Fifth Amendment issues, it really comes down to whether or not they are custodial interrogations.
So let's talk about that. When Miranda was the seminal case in the Supreme Court in the mid-'60s, and the court determined that if a person was interrogated when they were in custody, that they needed to be aware of their rights. It wasn't just enough for them to, for an officer to assume they knew their rights or assume that they were aware of their Fifth Amendment and Sixth Amendment rights, but they had to be affirmatively told these rights if they're in custody. So the court, after Miranda, has defined what custody is and what custody isn't. And so a lot of times people think, based on Miranda, that it's just simply whether or not you're free to leave. What that means you're in custody. And it's a little more complicated than that, because, a person that's stopped for a speeding ticket isn't necessarily free to leave, but those statements also don't fall under Miranda. So
No,
can you explain
not at all.
how that works?
Because it has to be custodial, and it has to be an interrogation. And a custodial interview is one in which someone does not feel as though that they can leave. It doesn't just have to be where someone is arrested. Of course, that does, or seized, like Harold said, on the side of the road. Obviously, that does play into it. But the custodial interrogation aspect of it means that you are in custody, that you basically, your freedom of movement is restrained to such a degree that it's associated with an arrest, and that you have to then be under some sort of interrogation.
Mm-hmm.
And that interrogation aspect implies that it is somewhat testimonial in nature. And the reason why is because, just like what we talk about every day, or on this show, in every single episode, we end with the Greenwood Law Bill of Rights, and we say, you're not to make statements. Don't make statements when you're stopped by law enforcement. The reason why is because any statements you make can and will be used against you, whether they are in the form of just your brief interaction and a stop, whether it's a custodial interrogation that would imply Miranda, whatever it is, you're making these statements, and they're potentially against your self-interest, and they can potentially be used against you, because criminal cases are one of the few contexts in which your statements as the accused can automatically come in regardless of hearsay rules. So if a police officer hears you say something, especially if it's against your own self-interest, they can testify to what you said, and it doesn't violate any evidentiary rules against hearsay. And so that's a big implication there. And, what a court looks at is, in its totality, your interaction, you're not free to leave, and does the police line of questioning or law enforcement's line of questioning create an environment where it's typical that it would likely elicit an incriminating response.
Exactly. And this is really important because, prior to Miranda, there was another Supreme Court case that essentially dealt with confessions, and that led to Miranda. But Miranda's important because, if you make a statement to an officer essentially confessing to a criminal, a crime, it's important later on for the court or any fact finder to be able to rely on that confession. And so that's where Miranda comes in, because if that confession is given under coercion, or what's perceived to be coercion, or that statement may not have the same veracity, or that confession may not have the same veracity. So it's important for those Miranda rights to be given to a defendant so that they are knowingly aware of what they are saying subsequent to being read Miranda rights. And if they are going to admit to something, it will have more weight in court. And that's where really Miranda rights could tilt a case one way or another, is if somebody makes a statement that is seminal to an element of the case itself, or admitting to the crime itself, and they weren't Mirandized, and they're in this is a custodial interrogation, that could make a difference in a case. So, I think it's important for our listeners to know they're probably thinking, what are some examples of when it is a custodial interrogation, what are some examples of when it isn't? And I'll start with one that isn't a custodial interrogation, and that is, you would think that if you're in jail, that it would automatically be a custodial interrogation. If a police officer or a bailiff or any person in jail, any law enforcement officer in jail speaks to you, and you would think, well, this is custodial because I'm literally in custody. And the courts have said that isn't true necessarily, that just by the fact of being in jail, you still have to be taken to, a back room somewhere, and the suspect would need to feel that they are not free to leave that environment, and as if they're under arrest, and then that may be a custodial interrogation as opposed to just being in jail. So that's one example of how custody works with Miranda.
It's always really interesting because we get to watch a lot of videos of law enforcement's interaction with the public as all these things are unfolding. And it's an interesting tactic that gets employed by police officers when they place someone in handcuffs and then follow it up with say, well, you're not really under arrest yet. You're not formally under arrest yet. This is just, we're doing this, for protection, or we're doing this for some other reason, which can be valid. But it's always intriguing to me because how many people feel like they can leave a situation when they've got handcuffs around their wrists?
Very few.
and even if you could, where are you going to go and how are you going to get those off even? Right. So it creates this weird set of rules because Miranda came down in 1966. It seemed like this huge, and it was a huge win. It was a huge win for everybody's constitutional rights. I think a lot of people look at it like, oh, well, this was a huge win for criminal defendants. And it's easy to say that because a lot of people look at these situations and go, well, that'll never be me. But the reason why you have constitutional rights is to protect you in case it is you and done so falsely or unjustly, because that's what happened back in the day. Before our country was founded and we had the Revolutionary War that we had, rights were just trampled upon. And so, to protect those was of high order. And so what was particularly interesting to me about Miranda, came out in 1966, is up until about the late 1800s, police didn't really interrogate. That wasn't a part of their job. Investigations weren't really a part of their job. It was just somebody did something, you went out and you got them and threw them in jail, or, you hung them or whatever else. You gathered your posse up and that was all she wrote. But then that started to change. It changed right around the Industrial Revolution, kicked some stuff off. It changed a lot of things in the country. And so all of a sudden, police were asked to interrogate, to investigate. And those tactics will range all over the place. And there's this big study that was done, and a lot of the things that came about in that study said, well, a lot of police, when it gets down to it, they resort to just beating people. If they want to get a certain piece of information, they just beat them. And that was found to be very troublesome, very problematic, because it is coercive to beat somebody and think that you're going to get reliable information from that. But it took all the way to Miranda for us to even get to a point where this was protected. Since Miranda, that's been chipped away and chipped away and chipped away. And just like you said, you've got a situation where just because you're placed in handcuffs, just because you're hauled off to the jail, you're not necessarily, the hook of a custodial interrogation doesn't fully, sink its teeth into you until you're taken to that back room, you're, isolated, and all of a sudden, you're being asked question after question after question about potentially self-incriminating stuff.
Right.
One of the things that police will do, if that's going to happen after an arrest, to just be, mindful of those potential issues is to get you to sign a waiver where they've informed you not just the, what everybody thinks during arrest, you have the right to remain silent and all that stuff. It's actually a written thing where you initial by each and every single one of your rights that you're waiving that, and then you sign it at the bottom.
Because the courts have said it's important that if a person is waiving Miranda rights, it needs to be explicit that they're waiving those rights. It's not, a person can't just waive Miranda rights by saying, oh, I think so, or maybe. It needs to, it needs to be explicit. So law enforcement has done that. And another thing law enforcement has done quite a bit, and this is something we talk about a lot, is that prior to arrest, especially detectives, they speak with people, but a lot of times that interaction is very voluntary. And the detectives and law enforcement will let that suspect know, hey, I am just talking to you. Your name came up.
They'll record it that way.
They'll record it that way. Your name came up. I just want to talk to you. You're free to leave at any time. And that helps that law enforcement officer, because if on the back end and they're in a trial, they don't have to deal with any Miranda issues, even if that, because a lot of times these interactions happen at a police station, or they do. And so that keeps them from Miranda. And so we advise people all the time not to make those statements to officers, not to make those statements to investigators without an attorney or without having consulted an attorney, because when law enforcement is asking a suspect to make these sorts of statements, a lot of times there has already been an investigation prior to that law enforcement officer ever contacting somebody. They've baked this cake. Talking to a suspect is literally the icing on the cake, but the cake has already been baked. And a lot of times the initial inclination for people is that, in any one-on-one interaction, it's difficult when somebody asks you a question directly not to answer that question. And especially if you feel you haven't done something wrong, you're thinking, well, let me just get myself out of this. And I know it's counterintuitive, but we'd say, not to make those statements. You're not helping yourself there.
Yeah, not at all. And, it's almost like what you're saying. It's almost like an impulse. It's a human nature or something that, you're being impolite if you don't ask. Well, at some point, politeness, you can be respectful and courteous, but, those societal type politeness, those goodities that you want to do, they have to go out the door for self-preservation. And that's where the big issue lies.
Welcome, WTOB listeners. Thank you for joining us on For the Record with Greenwood Law. Today we're talking about Miranda rights and your Fifth and Sixth Amendment rights, which are extremely important. And so the first part of Miranda we talked about is your Fifth Amendment right against self-incrimination, but there's also that Sixth Amendment part, which is essentially right to counsel in a criminal case. And of course, there's a whole lineage of jurisprudence about right to counsel, but in the Miranda context, officers have an affirmative duty to advise a defendant that they have the right to counsel, and if they cannot afford counsel, that one will be provided for them. That's extremely important because, as we know, in this job, and of course, becoming a lawyer, you see it every day, and doing this criminal law, that it is so important to have counsel when you're making any sort of statements to law enforcement, because this is about your future, and it can really have massive implications for any person. So that's why the courts recognize this, the importance of having counsel, and the Constitution recognized this. I mean, at the beginning all the way in the 1700s, it was important for the Bill of Rights to have that right in it for criminal defendants to have the right to counsel. So that's why Miranda has those two parts to it, and that's why officers have that affirmative duty.
Oh, you're exactly right, Harold. And I mean, it's one of the most important rights that you get because, as the old adage goes, the lawyer who has himself for a client is a fool. And I mean, typically that is the case. I'm not saying that people haven't ever won representing themselves. We've both seen it, but it is not rare, and there are more times that makes you want to cringe than you actually see the right outcome happen. when I think it's pretty easy to pick up that this is a fine line issue.
Yes.
It is extremely technical. It is one that is kind of subjective for the court in a way. They apply an objective standard, but it really comes down so fact specific. And so let's go through a couple of different cases. We'll describe them. We'll talk about how those ended up and how Miranda applied to them. This is basically just peeling back the curtain of how we analyze something, or what how a lawyer's brain works in this context. So case number one, you've got an individual. And this actually happened in a fairly close county where he is a confidential informant for law enforcement, and there was information given about something that was going down in a hotel room. Wasn't said specifically in the case, but it was implied that it was a SWAT team. They roll in, and all of a sudden, he does some suspicious stuff in getting up out of the hotel room. But then all law enforcement is just going through his room. They've bookended him on both sides of the hallway. But actually, they recognize him because, again, he's a confidential informant, and one of his handlers is actually there, and they know each other, and they're talking.
Right, and so they're if you can imagine, they're standing outside the hotel door room, and the defendant is speaking with this officer, and this officer is asking him questions about what they're doing, asking questions. There was another woman in the room, and he's asking about this woman, and eventually he's asking about whether or not he can search further in the room, and they do. He gives a tacit sort of gives the officer permission to search, and they find heroin under a blanket that he was sitting next to, and he eventually is charged with trafficking in heroin. But the issue at trial and on appeal was whether or not he was in custody, and whether or not that consent he gave to search was valid because he wasn't read Miranda rights at that time.
Right. And then there's a second case that came out, and this was an individual who was involuntarily committed at a hospital. So they're under the supervision of medical personnel at that point. Investigators come in to talk to them, and in the process of talking to them, they make a statement that as soon as we talk, you can leave. And they start talking. And they sat to the side of the individual at the hospital. So they were free to walk in and out the door. They were free to get food. They were free to get water, whatever they might need. There's all these things that they could have done back and forth between them. But those were the basic circumstances of the case. So in one of these, you have a situation where Miranda was found to apply, and that all the statements, every single statement that was made over the course of that custodial interrogation was kept out of court through what's called a motion to suppress. So all that evidence was bad evidence because it violated that person's constitutional rights. Then you have the other case where it was a situation where Miranda didn't attach.
Right, and so in the first case we described, the one where the defendant was in the hotel, the court determined that Miranda did not apply, and that this defendant did not need to be read his Miranda rights, or essentially he wasn't in custody is what the court essentially found. And they found he wasn't in custody because of the totality of the circumstances, and that's what the court tries to look at from that objective standard, and basically found that this was a conversation between this defendant and this officer, but at no time was he under any guise of formal arrest or was under formal arrest. He was able to give give answers to questions with regard to searching later, and he did give consent to search. And so the court really also found that his consent that he gave to search further was part of the fact that led to the fact that he wasn't necessarily in custody. And again, this is a fine line here about whether or not somebody is or isn't in custody, but it came down to a lot of the circumstances surrounding this interaction between the officer and the defendant.
Right. So then in the second case, you have somebody that was involuntarily committed. So already they've been restrained.
Mm-hmm.
Although it's a civil restraint, because that's a topic for another time, honestly, because there's a lot that goes into that.
We could talk about that.
They're confined in a hospital. You had investigators show up, and they made statements, basically the effect, they said, all right. And then after we talk about this, we're going to go get up, we're going to walk out, and you can have some supper and watch some Christmas shows on TV. That's verbatim what they said. And we're going to go back to work, and we're going to leave you alone. So the implication there is if you talk, you're going to be okay. You're going to go back to you're going to be able to leave once you talk. We're going to go back to work once you talk. And we're going to leave you alone once you talk. That was the implication in those statements. And the court said in that context that combined with an involuntary commitment, that it so severely restricted someone's freedom of movement that it arose to a custodial interrogation. And so because of that, Miranda did attach, and the person who was on the other side of it reasonably did not feel like they had the ability to stop the interrogation at any point and go anywhere or leave. And so, for that reason, you've got these two different cases that I think you can see that each one of them has things that you would go, oh, well, maybe Miranda should apply there. And then there are aspects of each where you go, oh, well, maybe not. As you can see, it's such a fine line with how it gets parsed out in the court system.
And that's why, because it's such a fine line of how it gets parsed out, it's important for all of our listeners and any person that's in these sorts of situations to understand that ultimately, whether or not you're read Miranda rights, it will be in your best interest generally to not make statements to law enforcement unless you have counsel present, unless you have counsel present or have sought the advice of counsel in order to do that. It's extremely important for everybody to understand that. And that's why Miranda exists, to protect you.
Right. And I think it's just important for all of our listeners to know that even if you're arrested and officers don't intend to ask you any questions, there's really no need for you to be Mirandized. It doesn't mean that they should automatically tell you all that stuff. And the majority of arrests that happen, I would say, Miranda rights don't get read. But it's only under these certain specific moments that does attach. But it is always just so important, out of an abundance of caution for yourself, again, have some self-preservation, that, because it's so difficult to figure out whether or not you're in a custodial interrogation setting, just assume that you always are, and that you need to remain silent. That's our biggest piece of friendly advice that we can give, that, it is always important to know and understand your constitutional rights, and there's no reason why you can't assert them. It's a huge part of what we talk about each and every single day.
If you're just joining us again, we're talking about Miranda rights today, and just want to remind our listeners again, if you are interacting with law enforcement, it's important to politely exercise your right to remain silent. There's nothing to be gained from answering their questions. It doesn't mean that the officer is going to take it easier on you because you are answering questions. And it doesn't mean that they're less likely to charge you. Again, these investigators are baking a cake, and your statements may be the icing on that cake. An officer does not have the authority to make deals necessarily regarding your case. We hear this a lot. The officer said that I would get, only probation. that's something that an officer really can't make that kind of guarantee to you. So again, don't make statements in lieu of that. In fact, every word you speak really just goes toward probable cause to arrest you. So remember to stick with the Greenwood Law Bill of Rights and stick with that, and you should be just fine. So we've talked about Miranda this week, and we've talked about your Fifth and Sixth Amendment rights. And next week, we're going to talk about searches and seizures and your Fourth Amendment rights and how all of that plays into, again, these constitutional rights that are so important to protecting every citizen in this country. So with that,
and before we go, as always, don't forget the Greenwood Law Bill of Rights. And that's first and foremost, I will not represent myself in court. You've got that Sixth Amendment right. Use it. I will not do law enforcement's job for them. 3, I will not make statements when stopped by law enforcement. That's your Fifth Amendment right. You don't have to make those self-incriminating statements. 4, I will not consent to searches when asked by law enforcement. And 5, I will not be my own star witness for the prosecution. Remember, everyone, stay safe, stay healthy out there. This is For the Record with Greenwood Law, signing off.